Hmm. And co-host for sharing the screen, we have to do that.
Yeah.
Madam, good morning. So we will have next session of yours, we'll tell you. Annapurna madam, you have to make Arup.
Yeah, I've made it.
Yeah.
Na? Not coming up.
Nah.
I did here.
You have to click on the name.
I have to click on?
On the
Hello?
three dots are there, no?
Yeah, I'm
Yeah, you have to click.
clicking there.
You have to click on the name and
Yeah,
then say
in that
make host.
mode. Yeah, in that host tools I've added.
Or you make me or Arup as host, we'll manage.
Yes,
Yeah,
yes,
correct.
yes.
But it is meeting settings I've added here.
Mm.
It's not showing. See, it's showing only host tools, YouTube, background effects,
No.
focus mode, and
No, you have
disconnected
to
all.
select the participant.
Participants. You have to
You
go
have
to
to
the
select the
participant.
participant.
No, there's no participant here. It is host tools, meeting settings.
Hagala madam, see you can see the people on the screen, no? You can see me.
Yeah, I've seen it. Yeah.
There will be three dots. You select that.
Something I'm missing. Yeah, I've added. Okay. I'm doing that, Arup sir. Ask all to unmute. That is what it's coming in that three dots.
Yeah.
No.
Okay. I just add 1 second. I got it. Sorry. Yeah.
Okay.
I made Venu sir and I'll add Arup sir also.
Done. I have done.
Okay.
Dada, you can start. आरूप जी आपकी आवाज नहीं आ रही है. Okay, he just stepped out. Ramandeep bhai, good morning. Gurjit sir, good morning. Pooja madam, good morning.
Good morning, sir. Good morning.
Good morning, sir.
Yes, I think. Yeah. So good morning, everyone. Yeah, finally, sorry.
We can start.
Yeah, we can start. Yeah, now I can share. Yes.
Okay. Do I need to give introduction of the speaker?
No, speaker.
Yes, sir. Please update your introduction. He must have added many more feathers to his hat.
For sure. Arupja, I am waiting for some High Court judgment of Kolkata. Of your...
Yes. I think now it's okay. Yeah, so good morning, everyone, and welcome to today's discussion that we are going to have on the GST tribunal. So I hope I'm audible.
Yes, sir, you are audible.
So now, as we heard the last day, we have discussed a lot about some of the core issues. So today we are going to discuss about filing of the appeals, actually institution of the appeals, because there are certain things that have been clearly laid down in the rules this time when the JSTAT rules are being formed. Because relating to this, there have been certain issues which have been faced in the SESTAT also, wherein many queries have been raised, why you did not put the cost title like this, why this was not paid properly. Like when you're filing before the SESTAT, it should be before the Honorable SESTAT of Kolkata, whatever the SESTAT is. So many times these things are not put in place. People have just said ST5 and they have filed it. So those issues were there. So now in the GST appellate tribunals, everything has been clearly laid down. So the first thing that is there is that an appeal to the appellate tribunal shall be filed online on GST portal. So that is there in the form prescribed under the rules and shall contain the following but details. So first thing is the cost title shall state in the goods and service tax appellate tribunal and also set out the proceedings or the order of the authority against which it is preferred. So again, this is the problem that we have seen at sometimes in the SESTAT, that many a time against which order we have gone to the tribunal that is not given in the initial cost title. So they fail to understand that this which order, because if there are multiple orders and they are hearing a bunch of orders, so sometimes this becomes a challenge. So that again here, that's why they have laid down that set out the proceedings of the order of the authority against which it is preferred. So which authority, the appellate authority, first appellate authority, which order we are again moving to the tribunal, that should be clearly laid out. Next, it has been clearly shared that appeal shall be divided into paragraphs and shall be numbered consecutively, and each paragraph shall contain as nearly as may be a separate fact or allegation or point. So this is again a new thing that we are having to see here, because it was never laid down in the previous. I was just going through the previous rules and all. It was never laid down that it should be, each. See, this is always there, that the appeal shall be divided into paragraphs. That was always there. It should be numbered consecutively. That is also there. But each paragraph shall contain as nearly as may be a separate fact or allegation or point. So this is something that has been added. So here I would like the view of the House on this. That does it mean that if I am stating a particular allegation, say 3B2A, I need to state the entire allegation in one place, or maybe the things could be distributed wherein the say in case of reversal of ITC, though the allegation is reversal of ITC, but under that again we have the broad headings like reversal of ITC because of credit notes issued by suppliers, reversal of ITC because of exempt supplies, reversal of ITC because of 3B non-filers. So why do you think the thing has been put here that each paragraph shall contain as nearly maybe a separate fact or allegation or a point? What's the view of the House on this?
I think, sir, this is done in order to have a better understanding of the same issue at one place only.
Right.
If we segregatedly figure out all those facts separately, then it would be difficult, I mean, for authority and probably to understand it and recollect all the facts and to understand the issue. So that is why I think they are mentioning that if an allegation, if it is a point, or if it is a relating to some fact, nearby all those points should be mentioned in one paragraph or in the nearby paragraph only. It should not be segregated enough for a better understanding only. And they have also used maybe. I mean, you should try at your best to bring them, but if situation needs, you can also do it.
Yes. So that will also give a channel of thought to the honorable bench, that they would know that all these facts or about the allegations, they are there in a particular place. So I think that is one of the reasons that this has been stated. So now the other view of this is that what would happen if, I have certain connected facts. So in that case, whether if I give it at separate places, whether that will be considered a violation of this particular rule. So that is again another thing. Like I am an exempt supplier. Sorry, I am a supplier who supplies exempt and taxable goods. So I'm mentioning that I'm supplying these exempted goods, these taxable goods, and whatever the things are. And there is an allegation against me that that I have not reversed Rule 42, 43 ITC because I'm making both the supplies. So does it mean that I have to put both these things together? The fact that I'm a supplier of exempt goods and taxable goods, and the fact that I have not reversed the ITC against Rule 42, 43. So maybe that is again another thing that they're looking for. That if this is there, these are connected facts and allegations, so maybe they should be put back to back so that we can have a better understanding of the things.
Usually, we used to put a table with all the issues A, B, C, D,
Yeah.
with tag quantification of the demand. So can that be still done, or it has to be in paragraph only?
No, that's what, ma'am. This time in the GSTAT, they've clearly it has to be in the paragraphs. It has to be in the paragraph, and each paragraph should contain separately, the facts. And so even if so, another important thing is that recently I was attending a hearing before an appellate authority, and he was also coming out with this fact that it was filed by the client directly actually. And what has happened is the same facts they are being stated again and again at different places in different way. Okay, and because of that, he was trying to say that why did you repeat the facts so many times? So I think that is what also the tribunal doesn't want. That is, the facts are there and we have stated them in one particular place in one way. We don't need to rephrase them and re-put them in different ways and put it again and again in different places. Just to emphasize the fact that this is not there. That is what we want to actually clarify in our submission, just to stress that we don't need to put it. And to your answer, I think now we cannot put it into tables because yes, there are some of the professionals, they follow the format of putting it into tables, that this is there. So I think now it would be prudent to put it in the form of a paragraph only.
Right, sir.
So next is about Arpit, your views on this? You want to share anything, or Venuji, anybody else? Gurjit sir, Unniji is there, Prahlad, everybody is there.
Sir, I think a paragraph can contain the tables also. It's not that you cannot have tables.
No.
So, like if I'm explaining that paragraph, it can be
inside
with table.
Inside the paragraph, maybe you're telling about 3 issues about that particular thing. Then only you can say. But inside a paragraph, like we used to do, say, put in 3 allegations together, and then we are discussing that. That would not be allowed in my view. Right now, what is happening, say in case of ITC reversal. So there are 3 issues, like one is reversal for credit notes issued by supplier, one is for 3B non-filers, one is for this common credit not reversed. Okay. So what we do typically is that we write that ITC has been reversed on this particular grounds, and these are the grounds, and then we go on to explain. So here, maybe now, once we go to the appellate rules, maybe for each allegation, like if it's a 3B non-filer allegation, it has to be put in separately, and we have to discuss what is the allegation all about. Then in a separate paragraph, we have to go for this ITC reversal for 3B, I mean, say common credit. We have to go with that. Yeah, Venuji. Yeah.
So, I would like to mention that they have now kind of uniformed. I have seen some appeals where if there are some 7 points I am fighting for, the draft used to be clubbing 3 points together, 4 points together, and mentioning. Rather replying each point independently and cross-referencing one point somewhere, they are very clear, like how we have the act, the chapter-wise, section-wise, followed by the rules. So the point relating to it, anything you want to discuss, you have to discuss there. The facts, allegations, your submission, put everything relating to that point at that place. And it, rather than having a large sentences, make it more into a tabular paragraph numbered for easy legible for reading. That is the kind of intention they have put in.
Right. So maybe somewhere we are moving towards income tax appellate tribunal format also, appellate tribunal, because there the stress is more on simplification of the allegation and the facts. I think that is also one more thing, because in the income tax appellate tribunal, typically the facts have to be stated in a very few lines concisely, and also the grounds also we mentioned in a very concise manner. So I think maybe that would be, as Venu just said, so that may be our intention to do, that we put it in a more concise form, in a paragraph form, and also comprehended in a better way so that it's easily understandable to the bench at a quick pace. Okay. Shravanaji, you want to share something? Yeah. Arpit, yes. Yes, Boli.
So do we intend to say that as Venuji was saying, that the fact, allegation and submission has to be clubbed together, or fact can be separate along with the facts detailed, and grounds and allegations can be separate?
I think here they say it can be separate, but the thing is that the facts cannot be clubbed together or the allegations cannot be clubbed together.
No.
It can be next to each other,
first
but
there
not
can be statement
together.
of facts. First there can be statement of facts, then there can be grounds of appeal. But it is not required, in my opinion, that facts and allegations and grounds have to be clubbed together at same place.
No, I think
Arpit sir,
Venuji is also not
actually,
staying.
Arpit sir, I think they are saying to file online on the Gestat portal. So
Yeah.
I think that form will have separate column for facts and separate column for grounds of appeal, na, sir.
No,
So
that is there. But
can't-
ma'am,
Huh.
RPG is saying about fact and allegations. So there is a fact. Fact is that I'm a chartered accountant. Okay, allegation is that 3B versus 2A, there is a mismatch. So what RPG is saying that whether we can put the fact and the allegation together side by side, or we need to state all the facts together, which is kind of a background that normally as we put, he's into the business of this and they're exporting these goods, this, that, whatever. They are the service, they have a service level agreement. Whatever facts we state basically. And the show cause notice was stated, was issued on this day, it was not signed, and all those things we put. And then we come with the allegations of the proper officer. So Arpiti, you're saying you're trying to say that, right? That we can
Yes, 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 yes.
put in the facts in one place, that these are the facts. That the fact is that
Ruchi, I have opened the, if you can allow APL 05.
yeah, one second. Annapurna ma'am, you have to make Arpit sir also the host.
Yeah.
Venuji is the host. Venuji, you're the host. So you can make Arpit the co-host. Yes.
Arpit bhai, go ahead.
Yeah. One second.
So this is APL 05.
Yes.
So along with this, there is a brief issue of the case under dispute, description and classification, period of dispute, amount under dispute, whether the appellant wishes to be heard in person, statement of facts are separate, grounds of appeal are separate, and prayer is separate. So thereby meaning statement of facts have to be clubbed together for the
Yes.
entire case. Grounds of appeal have to be clubbed together for the entire case, and preferably whatever are the grounds for a particular fact, they should be clubbed together in the case for grounds of appeal.
Right. And in the facts only, you have to state the allegations also.
Yes,
You
yes.
have to state the allegations clearly. But RPG, I wanted to discuss on another interesting thing also. They have mentioned point. If you see the rules, they have mentioned the word point. So what would be
Now
that?
you can share, Aruji.
Yeah. One second. So they are saying here, if you see, as nearly if separate fact or allegation or point. So what would be the perspective of the points basically here?
Aruji, to the extent I have read these rules,
Hmm.
they have been drafted not in a manner where each and every word has a meaning. There are so many grammatical errors in these rules, as if they have prepared some 2 years back and they have just put it on the portal and notified it.
Okay. Yeah, well, I was trying
But
to understand that. What would be this
in the
point here?
manner APL 05 has been drafted, I see that whatever are the facts or or the points, they have to be clubbed together, and whatever are the grounds, they are to be clubbed together and to be numbered in a manner that all similar grounds are at one place.
Yes. Right. And I think this is also a very important area because whenever we are mentioning the allegations, because as far as I've seen in the tribunal, most of the bench members, they are very keen to know what is the relief that you want. So normally
Hmm.
they go to the prayers, and that is how I see what is the relief. So surprisingly, after the relief, they go to the allegations. Okay, what are the allegations against you? Okay, you are an education institution, you are making exempt supply, and the allegation is that this will not be exempt supply, right? So I think that's why this, apart from the facts, allegations, also laying down the allegations clearly as to what are the allegations clearly brought against me. That, whether I'm preparing examination I'm giving examination support to education institutions. I'm doing their preparation of the admit cards, I'm preparing the question papers, getting them printed, giving the question papers to the school, getting the tabulation sheet, getting the mark sheet done. So that is the fact that I'm doing. I have the work order with them. But the allegation is that this particular service is not a service which is falling within the ambit of the exemption and notification entry. So why is it not a service? That even that allegation, if that is also clearly laid down, if that is there in the show cause notice, if you are fortunate to have that in the show cause notice, I think that also needs to be clearly said that whether they are not treating it as a service which is in relation to education institution, they are not considering that institution as an education institution, or they are saying that no, this is not a service in relation to examination. So in case of tribunal, because that is one marked difference that I've seen between the appellate authorities or the tribunal and the high courts. Wherein in the high courts, they depend more on the synopsis or maybe whatever we are putting in the initial arguments. What are the facts that we want to bring in the maybe first 2 or 3 minutes? In the tribunal, I've typically seen that they are very keen on knowing what are the allegations that have been brought against me and what is that exact relief. Because I tell my juniors that you have to look at that WhatsApp meme or that Insta memes that come. There is one common meme that comes, कि कहना क्या चाहते हो? मतलब आपका prayer क्या, आपको क्या चाहिए? तो again, on the basis of that, what is the allegation brought against me? What are my submissions? That is very important. So next we go to sub-rule C. Acha, Arpit, you want to add anything else? But we have discussed just A and B only.
Yes, we can go
Okay.
in.
Yeah. So full name, parentage, goods and GST and description of each party and address. So again, about this parentage, there are multiple views in the multiple groups and multiple people that we are speaking to. So some of the people of the view that parentage means, whether it's a private limited company, public limited company, or a proprietorship, or things like that. And the other people, some of them feel that, the parentage could be the fact that, we are continuing this business for maybe we are registered since 2018, 2020, and things like that. So I don't know what is the significance of putting this parent. RPG, could you study on this? What is the significance of having
No
the word
idea. No idea.
Yeah. Even in the different discussions we had, we could not find or comprehend as to. Yeah, maybe one thing is that after full name, say I'm saying the Tata Steel Limited, maybe the parentage could be that a private limited company incorporated under the Companies Act, things like that. Maybe that could be. That is one of the views that we have expressed. Okay, so then description
Go
of
through the meaning of parentage. It says identity and origin of one's parent.
yes. But यहाँ पे, I don't know what would be the context. Anybody else who wants to share who has maybe studied or gone through this particular thing?
Amandeep
Okay.
is saying individual son or daughter.
Acha, that way. That could be, yeah, that could also be one of the things. But why would that come into place in case of a non-individual? So
Partnership
that is,
or private limited.
yeah.
They could have, because I also agree with Ramandeep that this only can be scope of parentage. Other than that, there cannot be anything about parentage.
Right, because they could have said constitution, I think, more than the parentage. The word that could be used is constitution.
Better could have been constitution. Yes.
So then is the description of each party. So I think here we need to put in what are the kind of services, what are the supplies that we are making. And address is okay. As applicable shall also be set out at the beginning of the appeal and not be repeated in the subsequent proceedings in the same appeal. So I don't know what is the reason for putting in the caution, because once we mention all this, I don't think that is being repeated anywhere else. But it has been given as a caution and need not be repeated in the subsequent proceedings in the same appeal. So we don't need to mention maybe we have to mention, we always mention that only, the appellant and all. Yeah. We don't mention the GSTN number anywhere.
Name and GST number.
Yeah, so we don't mention this again and again wherever, but it's being given as a matter of abundant caution. Next is the name of the party shall be numbered consecutively and a separate line should be allotted to the name and description of each party. Yeah, I think this is very important because while working in the tribunal, we have seen matters wherein because of non-service to the proper party, matters have been rejected in a few matters. Okay, like here, because when I'm filing an appeal, okay, when I'm filing, normally what we do in the tribunal is we are actually giving the respondent as the person who has actually passed a particular order, the commissioner appeals. Okay, but here, now what would happen is that they are saying that the name of the party shall be numbered consecutively. So apart from the commissioner appeals, many a times what happens is that the simultaneous orders are being passed by, in many situations together, wherein we are clubbing all those things together. Maybe we want to also consider a particular order which is being passed by the DGI is raising a show cause notice and the order is being passed by the executive commissionerate. So here the question that is being asked in many places is that whether along with the commissioner appeals, who is the first appellate authority, do you also need to make the executive commissioner who have passed the order in original and the DGGI who has issued the show cause notice the parties? Because in SESTAT, till now the practice is that we make the commissioner appeals only the party to that particular respondent to the particular suit, to the particular appeal. So here, the purpose is that they have said that name of the party shall be numbered consecutively and separate lines should be allotted to the name and description of each party. And these numbers shall not be changed. Okay, so whether it would mean party only for the taxpayers, wherein the parties are the taxpayer and the directors, okay, the taxpayer or the partners, or in case the order is passed by the Commissioner Appeal, First Appellate Authority, we would also have to make the executive person who has passed the order in original and also the person who issued the show cause notice, the respondent here. So that is again very, I think, important discussion because that's what you are doing in the courts. In the SESTAT, we have not done, but I'm not sure why they are saying this. RPG, your views first, and then we'll go to the other views about the second part also.
What I think is that this is out of abundant caution they have put in. And what I have seen in some, and everyone would have seen that in some cases, CGST officials are passing a common order against the company and the directors for levying penalty under Section 122, wherein they are being levied with a penalty for non-appearance at summon. And so there might be a case wherein multiple parties might be involved. Else, a single party is there and we are normally make commission appeals as a party. Although in those cases also wherein a common order is being passed against the company and two directors, and director's name is mentioned only for Section 122 penalty. We have submitted letters before the authority to pass separate orders and grant temporary registration to the directors because directors would be filing their appeals in individual capacity, company cannot file. But this is the only reason I can see, and there might be other reasons which members can also share. Aruji, you are on mute.
Anybody else wants to share?
So in
ma'am,
case of
yeah.
the fake billing thing or whatever the bogus invoice which department claims, the notice is generally sent to between in ABC. Notice is sent to A, penalty B and C, and again notice goes to B, penalty A and C. Notice goes to C and penalty A and B and the directors.
Yes.
So the parties involved. Now, while filing the appeal, we would make a separate appeal for each of the notice. We don't club, correct?
Yeah, because that is what has been said. It will be as per the
Aruji, if we can go to Rule 19, Sub-Rule 3.
Order in original. Yes, I'll just go. It will be based on the order in original.
Rule 18, Sub-Rule 3. Rule 18, Sub-Rule 3 and Para
Yes.
B. In case of an impugned order is in respect of more than one person, each agreed person will be required to file a separate appeal. And common appeals or joint appeals shall not be entertained.
So, given that is there, I'm still thinking, where is that we are now referring the list of the parties?
Yes, so that is the main thing. One could be, I think, from the department when they are going to file it against the company and the directors together. Could that be a case? Otherwise, or do they want that as per the court practice, you have to make everybody the respondent in case of a revenue? So that is one thing that is not clear from here.
This is not a civil suit where you have A1, A2, A3, right?
Yeah. But since they have copied most of the things from High Court rules, I don't know whether they have copied this also. And so, just like in the High Courts, we have this practice of making everybody the respondent, starting from the Union of India to, in case of constitutional matters, to the Commission Appeals, to the Commissioner, to the.
See, the courts have, Arupji, the courts have a process where there are two individual appeals and it's a common cause. They would merge those, the writ that has been filed and they would do a common hearing.
Right.
I have never seen a tribunal doing like that.
No, that is the main surprise because even SESTAT till now it's 1-to-1 only. So this is one thing which is not coming out clearly as why the name of the parties and each party should be given separately.
So many things.
Yes. And the next part is, and in the event of the death of a party during the pendency of the appeal, his legal heirs or representatives, the case may be, if more than one, shall be shown by numbers. Okay, so again, this is the wonderful thing because when you are discussing about the change in the ownership and all, they're saying that the proprietorship can be converted to, it can be taken over by another proprietorship and all. But here they're saying that in the event of the death of the party during the pendency of his legal heirs or representative, the case may be more than one, shall be shown by number. So, in case of appeals, the deceased person can be represented by more than one legal representative, legal heir or representative. So here again, what would happen to 93 1A and 1B? That is again the question. So maybe both the legal representatives, even if they are not continuing the thing, so whether they'll become liable for the payment of the liability that is being arising. So that is again another question. Yeah, Venuji.
See, in case of a death of a taxpayer, and I would believe that the proceedings should start afresh. There cannot be continuation of the proceedings. Now, it's the proceedings is against that taxpayer. It is not the business of his. And estate may would have received some money, not received everything.
Right.
So the proceedings should be, though the liability is restricted to the estate, the legal heir may assume, may not assume anything. So
Right.
it's like again here, this is the regular court procedure is what is appearing to be drafted. I don't know whether in the death of a taxpayer the proceedings can continue. Anyhow, the CA represent kar raha hai, he will continue to represent. I don't think the wakalatnama itself will die. The person died, everything would die.
Right. No, but again, that is one thing that, since the original order was against the deceased person, so how can the proceedings be carried forward? So that is again one question which is there. And apart from that, if you see here,
If Arunji, if the legal heirs have informed that the person has deceased, and they have brought on record, it has to be brought on record that the person deceased and legal heir would be the party, and legal heir would be issuing a new power attorney to the authorized representative to represent them.
Right.
But the proceedings cannot be stopped. Yes, they might start afresh because legal heir wants to appoint a representative which might be different, or he might to be heard separately afresh on the issue. He might be having different points. But it cannot be a case that because whatever cases we have seen till now in high courts also, in GST, wherein legal heirs have approached to the high court, courts have only asked them to be a party and put their submission. They have not quashed the proceedings.
No, they've set aside the matters. That is the worst part.
Yes.
But the operation successful, but patient died.
Yes.
But mainly, why are we going to the courts? We are going to the courts so that the entire proceeding gets quashed, no demand raises. But with all due respect, what is happening is the matter is being set aside. So, the way fish se fresh proceeding chalu hoga. Again, show cause notice will be issued, all the orders will be passed, and only the thing is the name will change. Nothing else is changed.
Whatever cases are there in income tax also, the onus is on the assessee to put before the fact that the person against whom the proceedings are continued have died. And it is incumbent upon the authority to start the proceeding against the legal heir, not the dead person. But if they still choose to continue the proceeding against dead person, then the order becomes void and no fresh order can be passed.
No, that's why I want to draw the attention of the House to this particular section, 93 1B, that we want to do. मेरे स्क्रीन आ रहा है ना?
हाँ.
No.
93
नहीं आ रहा है.
Oh, अच्छा, 1 second.
We are still in 18 subsection 3 clause B. Sorry, 18 rule 3 clause B.
Yeah, 1 second. That's it. Yeah. Now I think 93 1B is there. Yeah. So if we read 93, why I wanted to bring this to the attention? Because of the change in the words actually. See, if we go to the second part, because I'm considering that, in this case, maybe first let us assume that he's not continuing the business and the appeal is there, and during the course of the pendency of the appeal, the proprietor has passed away. So if the business carried on by the person is discontinued, whether before or after his death, his legal representative shall be liable to pay out of the state of the deceased to the extent to which the state is capable of meeting the charge, tax, interest, etc. Whether such tax, interest, or penalty has been determined before his death but remain unpaid or is determined after his death. Okay. So here the words they have used is his legal representative. So it's basically a singular. So one person is being told. But whereas when they are going to the GSTAT rules, they're saying even more than one person could represent. So does that mean the liability will also be incumbent on both the persons who are going to represent? So that is again another thing.
One legal heirs have received the property, they both might be made the parties.
Yes, so that is what I'm saying. So here,
Yes.
because these words are being differently used.
Arup sir, can
Yes,
you
sir.
just simply look
Yes.
on singular and plural as a difference here? Because generally, a reference to a
Hmm.
singular has to include a reference to the plural. So
Right.
here, just because it is referred as his legal representative, it doesn't mean
Yeah.
that it is only one person. It means all.
But will it also include the legal heir?
Yes, all legal heirs.
No, but here they have not used the word legal heir. No, that's what I'm trying to say.
Oh, okay.
They have used the word legal representative here. And if you see, one second. I don't know in Zoom if you can share two screens together. That is maybe not possible. So here they have used the word. If you see,
शेयर कर दीजिए
uh-huh.
पूरा entire
Yeah.
screen शेयर कर
Oh,
दीजिए
okay. Yeah, that would have helped. That's ठीक. Now I've done this. So here, if it says that in the event of the death of a party during the pendency of the appeal, his legal heirs or representatives, the case may be more than one, shall be shown by sub number. So would this be different in the interpretation, or it would include legal representatives also include legal heirs? So that is again another important thing.
I feel again this needs correction as the proceedings would begin. I would believe these rules will get amended.
Yeah, because these are two things that are being added, and one thing is that when the legal heirs are being actually, if you see in the truest, in the real sense, only the legal heirs can be responsible because they are getting the state. So why the word legal representative, which is again a different thing, why that is also used? So that is also not clear here. Either in 93 also here also. So anybody's view on this as to why the word legal representative could have been used in place of legal heir in 93, 1A and B.
But Arunji, the courts have interpreted this term legal representative in all the matters which have come before which have been reported as legal
Yeah.
heirs. They have not differentiated anything between legal heir and legal representative.
So can you share any of the judgments so that we can, I think we need to study, I think we also need to study on that. Because representative, when you are saying the representative, it would be person who is representing you on behalf of the disease property. So it could be a legal representative also. I mean to say authorized representative also. Right. So what would be the definition of legal heir and why? What are the differences between legal heir and legal representative then? Okay, could the legal representative be also a person like who's going to take care of the state? You know, who's going to distribute the assets of the state? Could that be the person, even if he or she is not a legal heir?
Or can it be applicable to minors, something kind of that? Minors, so cannot be, like if they're legal here and
Yes, I think, yeah, that
something.
is again another angle, yeah.
Uh,
Okay, Arpit ji, I'll have to get
Yeah.
into another meeting. So can you take it forward from here? I'll just stop sharing.
Yes, Arunji.
Ah.
Just a second.
Uh-huh. So any other views on this? About
sir,
Yes, sir.
the legal representative will be any person who can represent the estate.
Right.
That person may be a legal heir or may be otherwise authorized. Say the legal heirs have not yet been decided or finalized because the estate is under
Right.
distribution. That is also could be a stage. But if there is a demand which is recoverable, tax which is recoverable, it has to be recovered from the state before distribution to heirs. So it may or may not include legal heirs
Legal heir.
also. Legal representative is a broader term. Whoever is capable of representing that estate. And like Uni sir said, the plural or the singular meaning can be there. And regarding this particular clause D, says
Yes.
whether it should be the legal heirs or representative, their names should be added as a sub numbers or not. It has to be wherever applicable. There can be situations where it will not be able to, that proceedings will just collapse and die down because that person is not there. Now the proceedings cannot be carried on. There could be some situations where that proceedings can still be, those proceedings survive notwithstanding the death of that taxpayer. So wherever applicable, if the proceedings survive, maybe the proceedings have to die down, but the tribunal has to be informed by a legal representative. A submission has to be made that that person has died, that information has to be shared, and an application to be made that the proceedings will now be closed down. So wherever applicable, a representation has to be made. That would be my understanding for this.
Thank you, Vijay. Thank you. Arpit, over to you.
Yes. Thank you, Ruji. So now coming to Rule 18, Sub-Rule 2, which provided notwithstanding the number of show-cause notices, refund claims or demands, letters or declarations dealt with the decision or order appealed against, it shall suffice for the purpose of these rules the appellant files one appeal in prescribed form against the order or decision of the appellate authority along with such number of copies thereof as provided in Sub-Rule 21. So therefore, what they have tried to say in 18 Sub-Rule 2, that there might be number of show cause notices, multiple show cause notices issued in respect of one order, but if there is one order, one appeal has to be filed. And it has to be filed in the prescribed form, that is APL 05, along with such number of copies as have been provided under Sub-Rule 21. So now the question is that 18 Sub-Rule 2, it includes number of show cause notices, refund claims or demands or letters or declarations dealt with the decision or order. So in my opinion, it contains that if a decision or order is having multiple issues therein, so the one appeal has to be filed against one order. That is what I could understand from 18 Sub-Rule 2. Any other views from the members?
I am also of the same view, Arpit.
I also agree. Because subsequently they have referred that one appeal has to be against one order only.
One order.
No,
So
let
now
us take an example.
Yes.
I had about, say, month-to-month best judgment assessments under 62.
Okay.
It is based on the same subject matter, and that is how they are best judged. That 62, I violated the timelines and I had to file an appeal. So I'll be filing an appeal against East as SMT 13.
Yes.
But since the subject matter is the same, while disposing
Yes.
of the appeal, the order and appeal could be taking multiple orders of SMT 13s and multiple appeals into a single order and appeal. Now, if the revenue wishes to challenge this order and appeal, there will only be one appeal against the entire thing. But
Nikeshan ji,
Ah.
for that there is 18(3)(a). I could just read 18(3)(a). In
Okay.
cases where the impugned order in
ये
appeal.
लेक्चर खत्म
has-
होता है 10 बजे, फिर बैठते हैं अपने 10 मिनट के लिए।
Praveen ji, if you can
कैंसिल
mute
कीजिए
yourself.
वाला पॉइंट।
Praveen ji, if you 18(3)(a). In cases where the impugned order in appeal has been passed with reference to more than one order is in original, the prescribed form for appeal filed as per rules shall be as many as the number of order in originals to which the case relates insofar as the appeal is concerned.
So my question here is, how many appeals will be filed before the tribunal, considering there are multiple order in original and only single order in appeal?
So each appeal has to be filed separately for the original orders in original, even if a common order in appeal has been passed.
Arpit,
18(3)(a) seeks to cover this issue only.
Arpit bhai, see, to the tribunal you are going against OIA only, no?
Yes, but
You're not
we are
going against
going.
OIO.
Yes, we are going against an OIA, but in such case, what they have provided in 18.3a, they have linked it with order in original rather than order in appeal.
Now, the order in original and the order in appeal, once the hearing by the appellate authority has been passed, there is merger, right? So why are we still focusing on the order in original? There needs to be only one aggrieved order in appeal for which they need to consider before the tribunal. What is the purpose of having 18.3a in the first place is my question.
Sir, Arpit sir, one more thing, how the monetary limits will apply in this case. Now, I have one practical case, if you may allow, please.
Yes, yes.
Now,
Yes, Abhijit.
two adjudicating orders were passed against me. I filed two different appeals. Now, in appeal, only single appeal order was passed, and that was passed in my favor. Now, department is definitely going to file appeal in tribunal. Now, the monetary limit is that one case is for 25 lakhs and another is for 15 lakhs. Now, if they have to file two different appeals because of this, then the monetary limit applies, and the one with 15 lakhs amount, the order, they won't be able to file appeal for that in that case.
See, technically, the monetary limit is not applicable in my view because you have exceptions. They can always call out an exception saying that this is the violating the intention of the section and everything. Even for some 10 rupees also, they can go.
See, in my opinion, see if they would have allowed single appeal for a multiple order in original for which a single order in appeal has been passed. Then, in my opinion, how could the appeal filing fees would have been calculated? Because the appeal filing fees is related to the disputed tax amount, and the disputed tax amount has to be seen for the each order in original. So I totally agree with Unniji that there has to be one appeal against one order in appeal, even if there were multiple orders in original. But this might be one of the reasons wherein, because once there are 10 number of appeals, there will be 10 filing fees and then 10 orders by the tribunal. This is the only reason. This is one of the reasons which I could see.
RPG.
Yes, Praveen.
So this is a settled position since number of years that appeal needs to be filed separately by all people, including co-applicants, appellants, and all the parties involved into it. Even in service tax, same was happening. Excise, same was happening. Even in High Court, same practice was happening. And as far as my understanding is concerned, when these rules are copied and pasted from earlier law, same practice they would be insisting on in the GST law also.
Praveen, yes, there was a practice, but the thing which Unni Krishnji is saying that once there is a similar order in appeal on the same facts, why there is a requirement to file separate appeals when the appellate authority themselves have decided that it has the same facts and the common order and the common decision based on the principle has to be passed. So they could have simplified it, because it is not that they have just copied it from the SESTAT rules. They have made a departure from SESTAT rules at many places in these rules. So they could have made it a lot easier because supposedly there is one order in appeal which has been passed. Now they are asking me to file 10 different appeals for separate order in original. So how the portal will be allowing me to file 10 appeals if there is a one common order?
But again, practically there is a problem because the order will be a single order, but there will be separate APL force.
What if a single APL 4 is issued?
A single APL 4 cannot refer multiple DRC 7s.
Yes. Now, one thing which has to be also be seen, that the appeals on for the GSTAT would be filed on GST at portal, which would be different from the common portal. So for common portal, the APL 04 would be uploaded on the common portal, and these would be then how they would be transmitted to the GSTAT portal and how it would be linked with the APL04 which has been uploaded in the common portal, which this also has to be seen.
But sir, may I, sir?
Yes, sir.
Sir, many times we have to look at the procedures or the things from the perspective of electronic ledgers which have been introduced by GST. So in the ledgers for each liability, there is a separate entry. That is why even if one order in original may handle different show cause notices, it is preferred that DRC07 should be separate, though now there are for multiple financial years also a single DRC07. It emanates from there. Let's say if there are separate ledger entries, let us assume like Unni sir was saying in his immediate submission, that if there are multiple DRC07 issued, that means for each DRC07 there is a separate entry created in the ledger. Okay. Now, when APL04 has to be issued, again for tribunal, the APL04 has to be issued as per the provisions by the jurisdictional officer. It will not be the tribunal who would be issuing unless and until those provisions undergo a change. For the first appellate authority, the APL04 is issued by the appellate authority itself. And again, if we talk about first appellate authority, APL04, since an entry has to be created in ledger, one APL04 cannot create multiple entries. Similarly, for APL04 for tribunal, they have to be created multiple. But this is as far as the ledger entries are concerned. But I agree with the basic point which you are making or we are discussing, that like there are single orders for multiple financial years and a single entry is created by a single DRC07, though we have seen both kind of DRC07 where for one basic original order there are multiple DRC07 and there are one original order which contains more than 1 year or more than one issues and a single DRC07 is there. So we are seeing both kind of practices being adopted. And these kind of practices are primarily emanating from the CGST side because they are still ingrained with their earlier laws and they are quite adamant to follow their earlier practices only and not changing on to the GST these days. So this can emanate, but yes, even if the tribunal passes against a clubbed appeal, I will use the term clubbed appeal for multiple orders in original. If the appellate authority has issued a single order, since the further appeal, second appeal to the tribunal is against that order of 107, it should have been rather one appeal, unless and until there are multiple APL04 issued. And again, if there is a tribunal's multiple points or multiple or OIOs considered in one order of the tribunal, APL04 has to be issued by the jurisdictional officer. Now, portal should enable that against one order number, there should be the APL04's multiple can be issued. That should be there. But it does not seem to be a good practice. The initial point which we made, it is just not we made, you made, sorry, that it seems like it is just an earning machine for different filing fee, multiple filing fee generating for the tribunal. But again, coming back to the submission I was making, that we have to consider things from the view of the ledger entries also being created.
Thank you, Guruji sir. Now coming to 18(3)(b), which provide
No,
in case
kindly address
Yes.
the earlier participants' questions regarding threshold limit. I don't think that Venusa's logic of going below the limit, that is an exception case. But in practical scenario, assuming the circular applies, that I think it is 224, right? Or 207, I don't know, one of these. What would be the scenario of computation of threshold limits in this particular case where only one order in appeal is therefore more than one order in original?
So in my opinion, each order in original threshold limit has to be seen individually.
That will be the stance that will work in favor if we want to say that by virtue of threshold limit, the appeal cannot be maintained. But if that is followed from their side, if it's a larger demand, if it's a smaller demand, it can work the other way. That is just because it is split into multiple periods, the thresholds won't apply.
See, again, this has to be seen for the appellate order also, because what CGST is doing, they are passing a common order but issuing separate DRC 07.
Hmm.
So in that case, the threshold has to be seen for each DRC 07 separately, or it has to be seen on the basis of a common order. Now, in this case, what the revenue is doing, they are flipping and flapping their own stand. When for 128A, they are not considering DRC 07, they are going by the common order. But in this case, at places where it is convenient from their for them, they change their stand and come to DRC 07 rather than the common order.
There is one more aspect here, like what's happening in Kerala right now because of our jurisdictional division bench verdict in Lakshmi Mobiles. There is a single show cause notice, but multiple stage adjudications by the same adjudicating authority, resulting in part by part orders arising from a single notice, for which I can have the flexibility of filing appeals for some or appeals for some other, not filing appeals for others. In this case, if department wants to contest this, how would they do it? Do they have to file a single appeal or multiple appeal?
So, so you want to say that there are multiple orders in original, although there is a single show cause notice, but there are multiple orders in original.
Yeah, because of this clubbing of financial years issue.
Yes. So in that case, if there are separate orders in original, then the separate appeals have to be filed for all the different orders in originals.
So even though there is
there
only a
single show
single
cause notice.
proceedings, ultimately there's a single proceedings, we'll end up filing multiple appeals and multiple appeals before the tribunal for year-wise and perhaps subject matter-wise.
Yes, for year-wise and perhaps subject matter also.
And if that's
And
the
this
case,
is one issue. This is
how would
one
we
issue
apply
which
the
stays.
threshold?
Then the
Again,
threshold would
individual-wise.
also be applicable on each order in original separately.
It's 9:59.
Yes.
But we need to differentiate between multiple DRC 7 and one order in original or multiple order in original itself.
Swamiji, this issue of multiple order in original and single DRC 07 or multiple DRC 07 and single order in original is something which would have to be settled by the courts in future, that what is the locus standi, what is the final document, whether it is the order in original which has been passed or whether it is the DRC 07 which has been issued. Because at present, revenue itself is not clear that what is the final document which they treat, whether it is the order in original or the DRC 07, which they are treating as the final communication or the final document which is being sent to the party. So this is something which has to be seen, and most probably in case of 128A, somewhere down the line, this matter would travel to the High Court and would be getting settled that what is the final communication to the assessee. It is the order, is it the order or the DRC 07? So final views from Venuji for today's session, as it's 10 a.m. already. Venuji?
Will conclude.
Okay.
Appeal filing
So
fee
thank
will
you to
be
all the
more than the relief sought for, probably, if this is the case.
What, Uniji?
Appeal filing fee itself will be more than the relief sought for if this is the
Yes.
case.
Appeal filing fees is a very big issue, and somewhere in next session we will be
Will
calculation
continue.
method.
Will continue.
Ultimate, what is the calculation method which we're going, and concluding today's sessions, because we have already passed today's time limit, as Venuji has also said. Thank you to all the participants for joining in and then sharing these views. And as we see that these DSTAT rules are in the initial timelines and would be getting amended as and when the practice would be starting before the tribunal, because to the extent I have read, there are many issues surrounding these tribunal rules, not only for the technical purpose, but at the initial level also. So it's good that we are discussing thread and wear on these rules and coming out of a trying to come out on a common opinion on these rules. So thank you to all the participants for joining in and sharing their views. Thank you very much. You would be closing down the Vinuji, you would be closing so that the recording gets saved. Arunji, are you there?